Now that Virginia Giuffre's lawsuit is not going to be dismissed, Prince Andrew has to respond. And he did. We're going to take a look at Virginia Giuffre's actual complaint and then Prince Andrew's answer, the response to all the specific allegations that Miss Roberts had. Let's start by getting our bearings straight. Remember that the complaint was filed from Virginia Giuffre. It looked like this back on August 9th, 2021. This was filed 15 pages long, and this is the complaint. It's Virginia Giuffre against Duke of York, Prince Andrew, in his personal capacity, a complaint. And so just like any type of complaint, you complain and there is an answer. The answer, the response coming from Prince Andrew, the Duke of York. And this just got filed January 26, 2022. You can see it's 11 pages. And this is an answer as well as an affirmative defense listing along with a demand for a jury trial. Now, some people are looking at this and they're saying, wow, jury trial. He's demanding a jury trial. Wow, that's amazing. Really, this is more sort of just kind of the form of pleading. You just sort of include that in your response saying, we want our day in court. We want to be heard by a jury of our peers. And so you can see it's just a one-to-one relationship. She's going to complain about a number of different things, complaining about 1 and 2 and 3. And Andrew is going to respond. He's going to answer every one of those complaints. All right, so let's take a look at how this is working now. Earlier, Virginia filed the complaint. You can see a lot of this we're already familiar with. Of course, this arises out of abuse by the plaintiff or of the plaintiff by Prince Andrew, the defendant. During 2000 to 2002, she's saying X, Y, and Z happened under paragraph number 3, saying that oftentimes they were paid $200 from massages to wealthy billionaires. And then number 4, that between 1999 and 2007, Epstein did something to more than 30 people. And so you can see 4 different paragraphs. And here in Prince Andrew's answer, his response, we have 4 different responses. Paragraph 1 denies. What was that? Well, it's that there was abuse that took place. Number 2 denies that there was anything occurring from 2000 to 2002. Number 3 lacks insufficient information about what is in paragraph number 3. And you can just see how the pattern goes. As we continue on, Prince Andrew is also going to be saying that as to paragraph 5, lacks sufficient information, really can't answer that. What's paragraph 5? Well, it says that like other minors before her, she was initially able to provide massages and thereafter engaged in additional acts. Plaintiff was regularly a part of the process when all of this took place. And so Prince Andrew is saying, I just don't know enough about this case. I'm so innocent that I couldn't possibly opine about whether this is accurate or not. Paragraph 6, one such powerful man to whom plaintiff Virginia Roberts was actually lent out happened to be Prince Andrew, the Duke of York. And so under paragraph 6, we have plenty of information there, don't we? Prince Andrew denies the allegation contained in paragraph 6. How about 7? He denies the first clause, and he lacks sufficient information to deny the remaining clauses. In paragraph 7, the complaint says Andrew was a close friend of Maxwell, denies that clause, and actively recruited underage girls, and he says lacks sufficient information. And you can see sort of the pattern that emerges, this call and response. Paragraph 8, Prince Andrew admits that he did meet Epstein, says this happened in or around 1999. He denies the remaining allegations in paragraph 8. That is, that Prince Andrew thereafter became a frequent guest. He says, yeah, we knew him. We met him there in or around 1999, but I deny the remaining allegations that I traveled around and was a frequent guest of traveling around the homes, including New York City and other places. Prince Andrew denies the allegations in paragraph 9. Those allegations are about feigning ignorance about the scope of Epstein's ring, saying Andrew refused to cooperate. He says, no, I'm denying all of that. Paragraph 10, Andrew also denies, says that the remainder of the paragraph amounts to a legal conclusion, and I'm not even required to respond to that. But if I am required to respond, I also deny. Paragraph 10, Andrew, says Giuffre, committed the assault and battery when she was a certain age. As such, Andrew is responsible for battery and infliction of emotional distress, and the damage has been severe and lasting. And so he's saying, I can't respond to that. That's your conclusion. But if you require me to respond to it, I'm going to go ahead and deny that. Paragraph 11 says this was filed timely. And again, legal conclusions under this. And so the pattern continues, but we're not going to take a look at the rest of the complaint because we can see that we can sort of surmise that a lot of this is going to fall within the same category here, that it is lacking in information so that Prince Andrew really can't respond meaningfully one way or the other. And this all pertains to Epstein's enterprise. Prince Andrew says, can't really comment on it, had nothing to do with it. We see another big bucket here. Defendant's alleged relationship with Epstein and Maxwell. And Andrew says, yeah, I knew Epstein, met him around 1999, but can't talk about any of the other things. Lack sufficient information to admit or deny any of the other information in any of the other paragraphs. See a big category here, defendant's alleged abuse of the plaintiff. Specifically, this is whether Andrew abused Virginia Roberts. Denies that. 38, we lack sufficient information, but otherwise it's all denies, right? He's got plenty of information here. He can say unequivocally, I deny. This continues. Now it goes into the arrest, the prosecution, the death of Epstein, and whether he was refusing to cooperate with the attorney or the authorities, really. Most of these are going to be the same, admits the second clause, but the rest of them lacking sufficient information. Then we get into the specific causes of action. Remember that Virginia Roberts is alleging that battery took place. That's the physical interaction that took place. And Prince Andrew is saying, nope, deny all of those allegations. Don't even need to respond to many of these things, but denying that. Also, the intentional infliction of emotional distress, another legal claim. Virginia was submitting this, saying that this is part of the complaint. And he's now saying that denied and no response is required, right? These are all sort of conclusory statements. If he is required to respond, again, denied. All right, so now we see that that's sort of a line-by-line rebuttal of the major portions of the complaint from Virginia Roberts, but we also want to talk about some of Prince Andrew's defenses. And these are things called affirmative defenses, which is, long story short, broad strokes, it's saying we're acknowledging that some of the underlying allegations may have happened or did in fact happen, but you still can't bring a claim because of these defenses. It's not talking about whether the actual underlying allegations are true or not. It's saying, well, kind of regardless of whether they're true or not, we can still raise these defenses that insulate us. So let's see what some of these defenses might be. One, lack of subject matter jurisdiction. Basically, the court has just no jurisdiction over the case. Virginia Roberts, why? She's a resident of Australia. She doesn't even live in Colorado. Colorado doesn't have jurisdiction over somebody from Australia. And so the court just should dismiss the case, not because nothing happened or did not happen, but because of a jurisdictional problem. Also, number two, an affirmative defense was Virginia waived this. She signed the release agreement that we've read through between Epstein. And even though the judge said that that's not enough to justify a dismissal on the case on the basis of a motion to dismiss, this is still also a waiver and release under some other, common law or equitable concepts. Third, latches. Giuffre is barred in whole or in part because of the doctrine of latches. And this is an old equitable doctrine saying that she waited too long. This case is old. She signed this stuff at 2009. And she didn't bring this claim. And so she should be precluded from bringing the claim, again, regardless of what happened or not. Maybe it did happen. But Andrew is saying because she waited so long, she should be barred from bringing the claim. 5, saying that, maybe she was harmed, but she consented to some of this stuff. She actually agreed to do this. Now she can't claim that she was injured. Unclean hands, that she can't bring a cause of action because of the doctrine of unclean hands, because her own wrongful conduct. She contributed to the situation and her hands are not clean, and therefore she shouldn't be allowed to recover. 7th, estoppel. Doctrine of estoppel, saying that her knowledge, conduct, words, or actions are showing that these claims should be barred. We see that there's 8th affirmative defense is here, the statute of limitations, which is closely related to latches, but this is saying that a statute of limitations is that by statute, her claims are barred. because a law is in place that precludes her from bringing a claim. Ninth is speculative damages. She's just sort of making up harms out of thin air. Nobody can quantify. They're too speculative to be recoverable. So even if this all happened, she's saying the harm and the damages are so abstract that we can't quantify them, and therefore we should dismiss the claim. No right to exemplary or punitive damages, saying that the facts that she's alleging have not justified any punitive or other types of awards in her favor. And if there's not going to be an award in her favor, there's really no basis for the underlying lawsuit. Failure to state a claim, saying that the complaint on its face is not sufficient. And then this catch-all paragraph saying that anything that they didn't talk about already might come up later, and they want to reserve the right to include it and sort of update this list of affirmative defenses. This is not an exhaustive list. We can see that they're saying now that they pray for relief, that the complaint and the first and second causes of action be dismissed with prejudice, that Giuffre take nothing by her complaint and the judgment entered against her in favor of Andrew, meaning she doesn't recover anything, and that Prince Andrew be granted such other relief as this court may deem just and proper. Prince Andrew demands a jury trial, which again is really more part of a formula of responding to a complaint. And so Prince Andrew, we learn a little bit more, nothing really substantive about what Andrew did, but we know that deny, the strategy that has always been coming out of Prince Andrew and his defense team will continue to come out of Prince Andrew and his defense team, and we'll follow it along as the case develops. We know that there's going to be a lot more discovery, and there's going to be a whole slew of motions filed back and forth in both directions as both sides continue to sort of beef out their legal strategies now that we know the case is in fact moving forward. We're going to continue to follow along. I want to hear what you think about the case, so let me know your thoughts down in the comments below. Be sure to subscribe because we have a live show that we do every weekday, and I'd love it if you joined us there. I look forward to seeing you on the next one.